Hello, everybody. Thank you for participating in the 21st Export Talk. This webinar series is organized by hub.brussels Export Talk team to help companies go international. Today, the subject will address the secondment of personnel. We are glad to have Michal Drab today. Michal Drab is lawyer at the Brussels bar and specializing in staff secondment issues. We will also hear Vincent Detemmerman, who works at the Construction Confederation as the international director. He will conclude the webinar by talking about the guide who produced it by hub.brussels. It will also address the specific issues of the secondment of personnel in the construction sector. So you can ask your questions in the chat during the presentation. We will ask them at the end of the presentation. And now I will let Michal start now his presentation.
Okay, hello everybody. So it's my pleasure to expose today the subject number 21, which is engagement and secondment of the staff when you are selling abroad. Maybe just a quick word about myself. I'm an attorney at Brussels bar in Belgium. Before I used to work at Deloitte and PwC, also in Belgium. The core activity is the advice to the entities and companies under Belgium and foreign law, with the specialization in European law, and quite an experience in commercial law, commercial litigation, and indeed in posting of workers, which is the subject of today. So normally now you should be able to view the general scheme of the presentation of today. Just let me present you every single point of those that you can see now, starting with general rules of posting of the workers to the European Union and to the extensive European economic community. Then we will try to go to good practices, where I will try to give you some good tips and information, sort of practical know-how, which will be based in this second point basically on 3 subsections, which will be inquire, prepare, and in case of problems, what to do. Then we'll follow 2 brief points, which will be the 3rd one and the 4th one. You of course have to be aware of the risk of not following the rules of posting of workers and employees abroad within the European Union, in the European economic area, and then some solutions that you can adapt while some mistakes has been done. Today's presentation will be ended by a session of questions and answers. As Jan said, you can ask already your questions in the chat. Well, posting is a very broad subject, so we will try to and a large subject as well. So we will try to touch as many of posting aspects as possible. Some slides are more detailed. Some slides of this presentation are just more general. So do not hesitate if some areas are more unclear for you. Just use the chat, ask your question, and if only I am able to answer at the end, I will be happy to provide you with this information, with the answer to your question. Of course, in the limits of the knowledge. So I just propose to step in in the general rules of posting, we will base ourselves on 4 points in this part, this general part. I will be very brief on the legal basis, which is usually the most boring part, except for the lawyers. Then we will pass to the posting of employees or workers to the European Union countries. Will follow the same subjects under point 3, posting of employees to Switzerland, Iceland, Norway. So the extended so-called economic European area. And we will finish with an actual point, which is posting of employees to the United Kingdom. I put into brackets special cases. Well, as you certainly know, nowadays all the cases related to the United Kingdom are quite special because of the Brexit issues. So we will try to present it in 3 points. What happened before the 31st of December 2020. Then what happens as from the 1st January 2021, so our actual current year, and then what is foreseen for future. So this is the 4th point of this general rules of posting. Is quite more complicated, quite more complex. So I will just try to give you a general point of view on that one. And again, please don't be shy. Just put your questions in the chat, and I will be able to answer to you. Hope so. Okay, so I propose to go to the legal basis. Well, just not to be very complete, because as you probably may know, and certainly you are not at all surprised by the fact that the rules of posting of workers, the rules of secondment of personnel to the European Union is governed by the European regulations and by the European law, which is afterwards, of course, transposed to the national legal system of every single European Union country, or it stays under a regulation, so it's directly applicable in the national legislative system of every single EU member country. As you may see on the slide, the first point is the EU regulation number 883 from 2004. It is fully and everywhere entered into force since the 1st of May 2010, and it is touching the core of the subject of today, because all the discussions around posting of workers within the European Union are always the discussions and the tensions about the social security coverage system. So mainly what happens, people ask themselves, also governments and politicians, where should be a worker, an employee which is posted abroad for a certain period of time, be imposed under which social security system, the country that sends the worker or the employee, or the country that receives the employee. It has been also a subject of quite a lot of media publications recently, because as you certainly know, just mid 2020, we were all somewhere into COVID crisis, but it hasn't changed the dates and the deadlines for applicability of the new rules of posting in terms of labor work. So not necessarily the social security system, because this stays under this EC EU regulation that is mentioned on the slide. But in terms of labor work, there has been some serious changes from mid-2020. Was a deadline for the 31st of July to implement new regulations, and Belgium has done it. We have the law of 29 May 2020, which was transposed and applicable, and which is applicable since the 30th of July 2020. So not even 1 year now. This is basically a copy of the European directive. Then on the second point, for the legal basis, if there are no special EU regulations or you post somewhere else, well, you will in some cases have bilateral acts between countries and then some multilateral acts. This is not a core topic of our today's presentation. We will just try to focus on the European Union posting of workers really in the so-called neighborhood countries, maybe more further to UK. And then concerning the European Economic Community, which is this larger form of the European Union and the collaboration with Norway, Iceland, sometimes Switzerland, and all those Nordic countries. There is a special regulation for posting of workers, which is the regulation 1408 from 71, quite an old one, hasn't been really updated, but it's not neither the core of the program of today. Very concrete thing, it's under this point 1.2, posting of employees to the European Union. I guess for those of you that are taking notes, normally those slides and this presentation will be available either online, either on request for you. So please don't hesitate to just follow and listen, and we will try to provide you with those presentations if you are taking notes actually now. Let's go further with the very concrete things about posting of employees, workers to the European Union. First, we start with the conditions. So as you might certainly expect, there are certain conditions that you have to fulfill to be able to post workers legally to other European Union countries. And mainly we speak about 5 big conditions, and those ones are mainly repeated. Well, first of all, it's the time frame. The time frame of posting is the maximum length of 24 months. I will further in the presentation discuss other options other than the maximum 24 months. But just for as a general rule, you have less than 24 months to post your worker, to send him abroad to work on a permanent basis. So it's the time limit that is in general respected, and most of the European Union countries, they are quite severe with these norms of 24 months posting. What does it mean, 24 months maximum? It means that your worker or your employee can stay under the Belgian social security system, so you continue to keep your worker under the normal Belgian social security system for maximum 24 months while he or she is working abroad. So that's the time frame. Of course, those posting periods can be shorter. It doesn't have to be 24 months. Then there is the second condition. They are random, so there's not actually an important numbering. So it's just another one. So the second one on my slide, it's the significant activity in home country. What does it mean? There also has been quite a discussion on that condition. It means that you have to have your core activity in your home country. So I guess in our case of participants for this webinar, the core activity of your company has to be placed and has to be performed in Belgium. Why the discussion and what was the issue? Before in time, before we got some clarifications in those rules, there was a discussion on those management companies. So some people were trying to argue that a significant activity was like a management company. It has been judged that it's not the case. So the European legislation by significant activity is in the home country, is meaning that you have your business really implemented in Belgium. It's not like just a part of business or side business. You really have to be attached to the Belgium by a large variety of links. So like an office, like workers, like taxation, like residency, plenty of those links has to be shown simply. Then there is the third condition. Well, if you post one worker, it cannot be a replacement of a worker that is going abroad just to make a switch with the one that you have already posted for, let's say, 20 months. So unfortunately, it doesn't work that way. So the time frame of 24 months was done to be respected. And if you say that, well, you want to continue and you send a replacement worker, a replacement employee that will do or perform the same tasks, that will be responsible for the same duties, and on top of that will be performing this work in the same environment and in the same geographical zone, well, one of the conditions will not be fulfilled, and then you take a huge risk to be requalified. We will come back to the risks of not following the conditions at the end of this presentations. For the fourth condition, the condition is to be covered or to be already covered by home country social security system. I will not enter into the details because this condition is also discussed between countries and also was discussed on the level of the European Union. Why? Because some, well, not in details, just to give you an idea, sometimes the question was asked if we can have a worker or an employee for a very short period of time, like a week or 2 weeks, so it's a fresh employee, and then immediately we send she or he abroad to be posted because that's the need. So some say it's possible, then some say it's not possible. In general, the simple rule is that you have to spend some time in the country, in your home country, which is most of your case is probably Belgium, and then only you can be posted. And we can see some tendency that is now going to the direction to say, okay, if there is an economical need and you can justify the need to send a freshman or a fresh woman, so a freshly recruited worker or employee immediately to cover a part of your activity abroad, it is authorized. So let's stick to this idea. The obligation of being under the coverage by the homeland social security system is there. So anyway, from the day one, your employee has to be covered by the social security system. And then on the day 2 or day 5, you can normally send it already as a posted worker to any foreign country. Then there is the 5th condition, and we are speaking here about employees. We are not speaking about freelancers in these presentations. If anybody is interested, I can just briefly say 2 words about the freelancers. But well, it's also a very broad and large subject. So I just try to focus on the employees. There is the 5th condition, which is the subordination link, which we call in French le lien de subordination. It is actually the link that exists between, and it has to exist not only in Belgium, but it has also exist once your employee is posted secondment abroad. So your employee has always to act under your authority. So there is no liberty in taking of decisions. And there is a follow-up of work conditions that has to be done. Follow-up of orders that you are giving to your employee posted abroad. This subordination link is also a very large subject that can be even the subject of separate presentation. Just remember when posting that among 5 main conditions, there is this subordination link. So never can happen situation like you sending your worker abroad and your worker or employee is becoming really well autonomous in the way of acting, and does not need to consult you on decisions, because for example, you consider your employee knowing better than the abroad markets in UK, in the Netherlands, Luxembourg. This subordination link has still to be there. Your posted employee or seconded employee has to maintain a link of authority with you that he always used to have in the past. After conditions, there is the point of formalities. You may ask yourself a question. Okay, from those 5 conditions, I can fulfill them all. There is everything that we are collecting internally in my company among those conditions. What are now the formalities that I have to fulfill to post somebody abroad, one of my employees or one of my workers? So the first one is the declaration. When you are posting somebody abroad and it's an employee acting based on a contract, you have to fulfill a declaration. So the fact of posting or secondment of an employee, no matter for which time frame, this has to be declared. Where it has to be declared, the answer is quite simple. To the social security system of your home country. How do you do that? Nowadays, you have basically the internet applications and the online devices to do that. So, for instance, in Belgium, you just go on the site of either ONSS or RSZ, where you can just click, put all the data of the employee to be seconded, of the employee to be posted, a worker to be posted, and then you will get in return what is mentioned in the second point of this slide, so A1 form. It's an absolute basis. So on the day your worker is starting work abroad, let's say on Monday, if the worker, if your posted employee has to start performing his duties, let's say in London, normally 9 a.m. she or he is starting at 9 a.m. You have to have already the A1 form. You will see in the tips that I'm providing at the end of this presentation that having this A1 form is important, and among other documents that you have to provide your employee while sending her or him abroad. You will get this A1 form normally on your virtual box. So it's I think it's been a long time that I've seen A1 form sent by post. So nowadays it's mostly delivered by internet. Of course, there are obligations to identify yourself, but well, this is not a core of this subject in this presentation. Just to ease your duties and just to ease your procedures when you will send any of your employees out of Belgium, I put into this slides two contact ways. The phone numbers are the phone numbers for French part, which is ONSS, and this is the direct phone number for the directorate responsible for posting in Belgium and delivering A1 forms for Belgium. And then RSZ is the second number. You have also two email addresses. They answer quite quickly. So you can also, via those contacts, so via the phone numbers or via the contact emails, ask all your questions that you have concerning posting and formalities, in particular direction that you are going. Because today we will not discuss the particular rules like for posting to France or to posting to Luxembourg or posting to the UK, because it's just too large. Every single country has its own specificities. But you get those numbers and those emails. Don't hesitate to contact them. They are there for you, and they will give you answers on the questions that you might have on the declaration in A1 form and any additional question. I used to have a question in the past for one of my presentations. If we are sending our employee just for one day to France, do we have to ask for A1? And well, I might let you to find the answer for a while, but it is yes. So even if you are sending your employee for only one day, it can be only 4 hours, let's say to Lille in France, for I don't know, a seminar or a presentation. Normally, under European Union rules, general rules, you are obliged to fulfill an A1 form for her or for him. It's slightly different under those post-Brexit rules for the UK. We will come to that point a bit further. It might be surprising, but it's true. You have to be in order with those declarations, even if your employee is going for 3 hours to France or to Luxembourg. which we don't usually mind and which we don't usually remember posting our employees, or basically we don't know because we consider it such a short time that we don't have to. Well, we have to according to the rules. Let's go to the special cases for posting employees to the European Union. So I mentioned you on the first point, the 2 slides before, that there is a general conditions of spending not more than 24 months out of Belgium for your worker. This conditions is one of the can be subject of an exception. So if your project is getting slowed down by, let's say, COVID now, or by any other explicable circumstances, and you are obliged to leave your employee out of Belgium for more than 24 months, you can ask for that. You can ask for that. You just have to motivate in the right way, and then you will receive an answer with authorization or denial, which will be obligatory and mandatory then. So if it's positive, okay, that's good. But when it's negative, it's very difficult to overrule it and to find another solution. In any case, even if you are asking for 1, 2, or even 3, 4 extensions above the period of 24 months, there is a time limit, and it's an absolute time limit, which is 60 months, which is 5 years. So in other words, in other terms, you can post your workers and your employees and keep them under the Belgian social security system with no obligation for double payments for maximum 60 months, if you have good reasons, of course, 60 months being 5 years. You will certainly ask me who decides on these extensions and where do I have to address my my question of getting an extended period above the 24 months of secondment. It is the ONSS and the RSV that decides together in communication with the country of posting, not the host country, of the country of the host. So, for instance, well, you are mostly Belgian residents, so you just ask Belgian authorities for a prolongation, and the Belgian authorities they enter in contact with the country which is the host. Can be France, can be UK, and then together those maybe UK is not the best example now, but can be France, can be Netherlands, can be Germany. You ask, they enter into communication. If they don't see any inconveniences, you are granted for this extension, and then there is the possibility, if you have good arguments, reasons for the second or even the third one, depending, of course, on the reality of your project. So the decision in general and what you have to ask is in Belgium. So you ask your homeland social security system, and then they just do the work for you normally, presenting your reasons. This, I think, is enough for the special cases and extensions. There is the issue or the question of posting of employees, and it's the third part of our presentation, which will be quite brief. I will just explain you two differences here with Switzerland, Iceland, and Norway. So the extended economic European economical community. which is the European Union and those additional countries. So actually the same rules are applicable as for posting. So the same conditions has to be fulfilled. You see that under point 1 of this part. And then the same formalities has to be followed. This is in the point B. You will see the formalities. You will remind yourself what we've been talking about just briefly before. You see that there are kind of derogations from 2011, and indeed Switzerland, Iceland, and Norway, and some other countries which are called sometimes problematic EU countries, such as, for instance, Denmark. They have derogations in those posting rules. What do I mean by that? It's a very particular question. Within the European Union, most of the countries, I mean a huge majority of the countries, except maybe 2-3 countries, they accepted posting of workers that were not EU nationals, but they had the right to work on the European market. So let's say you are an IT company based in Belgium, just an example, and you may well you want to extend and you just make somebody come from India, an IT specialist from India, to work for you in Belgium. So based on the work permit, this Indian citizen can work for you and can also be posted in most of the European Union countries, except those countries that we are mentioning here, because they have a derogation on posting the non-European Union citizens, and the same applies for Denmark. So you cannot post this Indian IT specialists in Denmark, unfortunately. So this is a specialty. It's not very often seen, but it can happen that you might find this kind of case in the future. I propose you to go now to a very interesting subject and to special cases concerning United Kingdom, as Brexit has its impacts on many of so far European Union rules. Unfortunately, it has also its impact on posting of workers. There has been some uncertainties on the subject. Now it's more clear. It still has to be precise in several fields. I will try to be as complete as I can for those rules, and we will be functioning in different time frames. So the first one will be the time frame until the 31st December 2020. Then we will go to the situation as from this year, so from the 1st January 2021. Then we will do on top of that a split on what happens and on the new obligations for employers and employees, posted and posting, because of the Brexit rules. So to start with simple things, you certainly might know that until the 31st of December 2020, so all last year, we had transitory rules, and basically all the posting situations were staying under the same formal rules. The European law was still applicable for the UK and for posting of workers, and it was just the same as before. So the UK was not anymore part of the European Union, but for whole past year until the 31st of December, always functioning under so-called old posting rules that we have presented. As from January 2021, so freshly this year, few months only, we have sort of new acts of cooperation with new rules. The act is actually called a Commercial Cooperation Act. And the main change in posting of the workers from Belgium to the UK, also the opposite. But what is interesting us more is the point of view of Belgium, so posting from Belgium. The main change, as I said, is that there are no more benefits of the EU principles or morals in the social matters. What does it mean very concretely? Posting will be slightly more difficult. It will be governed by additional obligations, which will be, on top of that, different from what you might know internally within the European Union. To give you an idea, a precise idea, I decided to present you in the next coming slides a very important thing, which is the importance of the begin of the activity. So we have to make the distinction between two types of activities. Activities that has been already ongoing before 2021. So let's say you are collaborating and you are posting already for several years. This is one bench of rules. And then you have the activity started as the 1st of January this year, January, February, March, and ongoing, and also in the future, which are governed by all other bench of rules. And then, not to make it too easy, there has been made another split between the rules for the employer and the rules for the employee. Of course, the employer can help the employee to feel some of those new obligations, but it still has to be done by the posted worker. So let's not talk too much. Let's go further with those concrete cases. On this slide, you can see the beginning of the activity is before 2021. So we are in the situation of the continuity, and under numbers 1 to 3, you see what changes or doesn't change for the employer. So if your company was already active on the UK market before 2021, you as an employer, you have no need to ask for a work permit for your seconded personnel in UK. If it's a continuity that you are making for your personnel, so somebody used to go to UK, all sort of works, and now is continuing to do it in 2021. So the general rule is no major changes. Your personnel will still remain under the Belgian social security system. It's a sort of status quo if there is the continuity of working abroad. On the next slide, let's see what happens and if there are any new rules for the posted employee, for the posted worker. Also, the same situation, the same case scenario. Your worker, your posted employee, has already been working before 2021 in UK on sort of permanent or semi-permanent delegation basis. there is a new rule for this this worker of yours in UK, and this worker has to ask United Kingdom authorities to deliver him with a certain form, which is called the settled or pre-settled status. So basically, it consists on going to the local administration and filling a paper based on some questions telling you either you are settled or pre-settled in the UK. What is important concerning this point is the deadline. So even for those that has already the habit before 2021 to work with UK, the worker has to ask for this settled or pre-settled status in the UK, and the deadline for that in UK is the 30th of June 2021. So there is not really much time left, it's around 2 months now to fulfill this obligation. I propose to go to the interesting part. So major changes because of the Brexit. What happens if you are new or you will be new on the UK market, or you will just start the collaboration with the UK? Well, if you are an employer and you start your first collaboration and the first posting to the UK only from 2021, so from 1st January, I can give you 3 advices. Well, search for a business partner in UK. This is like a stable collaboration, and join it with the second point, find a sponsor in UK. What is the principle? The principle is you have to be somehow invited to come and work and to send your posted worker to the UK, and you have to have a certitude that you have a host somewhere in UK. Then there is also a third solution. You can create as an employer a side activity or a representative office in the UK, and like that the transfer of your employees, secondment of them, will be much easier with much less of formalities. But you have to pay attention. It will concern only the management personnel, also stagiaire and employees or workers that are practicing at your company. So not a very large amount of types of employees, workers. On the next slide, so here we were into the obligation and some tips for the employer, and then we go to the next point, which is the same. You are only starting for the first time of your life a project in the UK in 2021. What are the obligations for your posted worker? There it becomes as well a bit more complicated. Your skilled worker has to ask for a visum. It's a sort of a visa, simply. And no matter the time of posting, actually, you are just posting for 2 days. Anyway, you will have to apply for this UK visa. I will not enter into the details of the, maybe it would be a subject of a further presentations in the future, but the UK system that they put in place, it's quite a special system based on points, and basically to get the visa and to make it easier to get the visa, you have to collect as many points as it is possible to be admitted to to the market in UK as a posted personnel. So you have to get 70 points. This is the information that I give you on the PowerPoint. Or if you are qualified, you get already 20 points. Then if you have a diploma, you get another 20-30 points. Of course, the diploma in the area of your specialization. So we get already 50 points. As I said, the goal is to get 70 points, and with those points, you are admitted to be seconded. It's quite an administrative system, and there are some cases, some special cases below, which are either subject or not subject of this new system, and this will be particularly interesting for you, I might guess. So I propose to go to the special cases, see below, the last point of this slide, which is future and special cases. Unfortunately, future is unclear, and as you might read on the slide, this topic is not one of the priority concerns of the negotiators now, and so there are other issues under this commercial common agreement between the UK and the European Union, which are considered being more important. So for time being, it is functioning under this basis. I just wanted to present you two special cases for this new regulation. The internal mobility within one company, as I said, secondment based on the internal mobility in one company is possible. However, it is limited to the management in general, or to the directorate functions, not accessible for the secondment on posting, or posting is not accessible to every single employee of your company, with no need for this visum and additional administrative paperwork. And then there is a special case too, which also might interest you in your activities. There are some particular categories of either types of or purpose of your employee worker going to the UK, or some sort of activities that make this posting, secondment much easier and less heavy on the administrative basis, with no need for asking special permits and visas. So these particular categories precised under point special case 2 are, for instance, meetings. So you can quite normally attend a meeting with no need for a visa. You can also post your workers for negotiations and commercial negotiations with no need for any extra obligations going to the UK. This also concerns more basic activities, like, for instance, in trade, some installation works. Let's say you did send a machine, complicated one, to UK. You are free with no more additional paperwork. Send your installation crew and staff to UK, and the same rule applies for maintenance works. As you may see, I put three little points at the end of this bracket. Unfortunately, well, you shouldn't have much more hope, unless for now, to find more particular categories in there. I put those points because the subject is, well, since it is unclear and it is in transition sort of movement, there might be other categories that will appear among the meetings, negotiations, installation, and maintenance work. In that cases, you don't need the special visa. I look at my watch, it's already 2. So we will go to the second point, which is the good practice and some tips, which will be presented in 3 main subsections, which will be also shorter than the first part. So if you are already bored, you shouldn't be worried. I will be finishing this presentation any soon. So first of all, good practice is inquire, then prepare yourself and what to do in case of problems. Here I will just give you a bunch of ideas that you can you can use. So the first thing and very important thing, and I think I might be supported in that one by many practitioners and many specialists in the posting area, is to inquire. So before posting, a good practice is first to collect the information, especially in these uncertain times. On top of the social security issues, which are the most concerning ones, on top of those ones and the tax issues eventually, in those special times of today, you can have any other conditions that can be imposed to you as a company that is posting workers or employees secondment or practicing employees secondment abroad. Also in terms of medical obligations, which I'm not discussing here because it's from case to case, from country to country, a different regulation. But the general idea, the good practice point, this one, is to inquire where you can do it actually, and it's my duty to tell you how to do, how to proceed. Where first of all, start in Belgium, because Belgium has its Foreign Affairs Ministry with a whole bunch of information about every single foreign country, which is normally listed already online. Then you can add additional questions for the particular desks at the Foreign Affairs Ministry of Belgium. So just don't hesitate; they are there for that, and just ask your question before posting. And then earlier in these presentations, you got the phone numbers and the migration department emails. So just email them if there are any additional conditions or any additional formalities above the formalities that I have already presented you in the first point of this presentation. Then the second reflex that you have to have concerning inquiring about the rules is once you arrive or you send your posted or seconded employee on place, just ask the locals, just ask the local the local authorities. Under point D of this slide, you can see what kind of question you can ask. You can ask questions about the remuneration, about the authorized stay time, about accommodation. Well, all those questions are different from country to country, or they should be similar, but we are not yet on that point in the European legislations, maybe one day. But for the time being, there is a very useful tool that is presented under point C to inquire yourself and to clarify yourself directly country by country. Go to the European Commission internet site, which is the one listed under point T, under the useful links. There is also the internet site of ONSS FSV that is becoming more and more complete. And if it's not complete enough, you have the numbers or the emails that I gave you earlier in this presentation. So don't forget, prepare yourself. I mean, inquire yourself. Yes, as I said, second point. After inquiring, after asking yourself questions about the posting, you have to prepare yourself. Prepare from 2 points of view, the documents and then the confirmation from the local authorities. why not? I mean, documents, it's easy. The basic are the ID documents of your posted employee going abroad. Then in some kind of situation, it's good to have a translated contract like on board for your seconded employee. And of course, this is just a basic rule, the A1 document that has to be filled before you start any secondment, even if it's a secondment of 3 hours just on the Belgian-French border in Valenciennes, let's say. Then there is a second preparation that you can do, the confirmation by local authorities. You can check with them the applicable rules, if there is anything special that you have to put into your mind, if they have any special demands concerning the social and the tax legislation. For that, easy thing is to consult the internet sites of the embassies of those countries that you are choosing to post people to. You just make a check and make sure that you are not in an illegal situation, because we are quickly coming here to some risks, and I will present them to you. In case of problems, of course, I promised to say to you what to do. Well, what to do is, of course, contact in Belgium your social security system and their representatives. So either for the French-speaking, it's ONSS or RSV or INAMI for the freelancers. So just don't hesitate to contact them. And then if any problem occurs, you get any letter or one of your employees seconded to abroad for a longer period of time is getting some kind of letters from local authorities, don't hesitate to ask them, or even to put them in contact with your Belgian reference, because in various cases they act without your participation. So Belgian system representatives are just entering in contact with the foreign system representatives, because that was one of the purposes of the of the reform, to create central points in all those European administration, central points of contact. And we have to say quite honestly that it works. So we can see that there is collaboration between those central points of communication. And as I promised, as you can see, I go quicker on this second and on this end of presentation. As I promised, I will go to the point, which is the point of risks. Well, in terms of risks, they can be severe. So, so really just ask yourself questions, prepare yourself, inquire, and then if anything happens, just go and ask. You will see in the next point some solutions that I can give you. Concerning the risks, well, Belgian fines, maybe that's not the main risk, and it's a subject of interpretation, how we can interpret a fine. It's quite rare that Belgium is sanctioning you for not fulfilling the foreign countries' obligations. In contrary, when it is discovered that, well, you are regularly posting employees or sending them for a secondment abroad with no A1 certificate and with no declaration, well, there you are subject to Belgian fines. As you may know, Belgian fines in terms of social security and tax are two kinds of nature of fines. From one side, you have administrative fines, which are the amounts that you have to pay, which can be quite considerable, can go up to 160,000 euros, depending, of course, on the number of posted workers or employees. Then the second risk is the requalification. So if you don't observe the conditions, don't observe the time frame, let's say, and or you just forgot that you posted somebody, one of your employees is seconded for a too long period of time, and you didn't ask any extension, you might have that situation of requalification. What does it mean? It means that you will be requalified as a foreigner employer, and there we come to the point number 3. You will be unfortunately subject to tax and social contributions to be paid abroad, sometimes on top of the Belgian social contributions, and then it's a huge mess between which contribution has to be paid, which country has to pay back what you have already collected for your posted worker. So so just try to avoid this kind of situation. I promised also to tell you briefly about the solutions. Yes, awareness. So so asking questions yourself and inquiring the authorities before posting. This is certainly a solution. And then preventive actions. So prepare your posting, prepare your secondment, prepare also your employees for the new rules. Just tell them how it works in Brexit, that they have new obligations, or try to well, make them understand that there can be fines and there can be liability. And as a second point of solutions, it's act immediately. So if you receive any surprising documents, letters from local authorities, from Belgian authorities, well, the time frame for the answer in some countries is between 8 and 15 days. So don't wait until the last day to prepare an answer, because it might be too late to act. It might be too late to find a solution. It might be also too late to be granted with a kind of flexibility. So remember to, from one side, prepare yourself, and then in case of problems, to act immediately here in Belgium, firstly, and then abroad via the multiple contacts that has been already given in this presentation. Yes, we will go now to the questions and answers part. If necessary, do not hesitate to ask your questions, as I said at the beginning, via the chat. I think that from that point,
thank you, Michal.
Yeah,
yes,
can
there are a few questions. So the first one is, do I need to adapt a working contract for posting workers abroad?
Okay, so I have the answer directly for this question. It depends from country to country. So it is more a question from the social security point of view. In most of the cases, no, because if you follow the conditions and if you follow the formalities, from the social security point of view, your seconded or posted worker will stay under Belgian system, so nothing to change in the contract from that point of view. But since it's a very good question, there is, as you certainly know, from mid-2020, I presented it to you briefly, all this new obligation of in terms of labor law that might be applicable, and in general for a normal posting period, so the periods not exceeding 12 months in a row, you don't have to modify the contract. Then eventually when you are posting somebody and it's like a bigger and more stable project for the future, eventually, and for a much longer periods of times, eventually you could make a change in the contracts by putting inside the reference to the national rules of labor law of the host country. So of French labor law, German labor law, Italian labor law, whatever, wherever your seconded employee is going. But in general, I mean, for normal situations, it is not advised to make any special changes or to put any closures in the contract. It's not an obligation to be fulfilled. In some particular questions, and this is important, on top of the employment contract that you will have with your seconded employee. So on top of the rules which are inscribed in this Belgian contract, in particular situations for a long range posting, you as an employer will be obliged to follow labor law of the country to where you are posting. And this might also be an opportunity to you as an employer, first when you are approaching to this period of more than 12 months, to contact the authorities, the social security authorities and tax authorities of the country that is hosting your seconded employee.
Okay, thank you. The second question is, may an employee refuse to be posted abroad?
This is more a question of Belgian law, and it enters more into the Belgian labor law and into questions that are mentioned also in your contract. So as you may recall, among 5 conditions of posting, there is one condition which says the link of subordination, in French, lien de subordination. It means that well, you as an employer have a certain power on your employee, and actually it's a case-to-case scenario. You really just have to check what is written in the contract. Personally, I haven't seen many contracts which it was clearly written that the employee will not be seconded or the employee will not be posted abroad. Nowadays, this flexibility is quite demanded. But of course, you have to check more into Belgian labor work and more into your internal contract with your employee and into the rules of the work regulation. So each company has also and the work regulation, which specified what is allowed and what is not allowed. So so those questions are in most of the time just negotiable with your employees, but it's more a question of the national Belgian labor law and of what is in your contract than a question of general rules of European law, because European law doesn't say anything about that. In contrary, as you certainly know, the European law is very positive to the direction of posting and making the internal market of people moving.
And the last question is, do I need to fill in A1 form for commercial working on my company booth in a commercial fair in Germany?
Yes, so this is the case that I told you already. This is the surprising thing. I mean, of course, all that if we want to be fully legal and if we want to be fully compliant with the law and with the obligations. Even for I don't know, you have a seminar or you have a workshop, as I said, in Lille in France, or you are going to Aachen, which is just on the border with Belgium and Germany, and you are going there for half a day, or you are sending there one of your workers for half a day. So the law is clear on that side. You have to file the A1 declaration. So you have to declare that you are posting somebody for even half a day. That's the rule. Then there is the practice aspect of all that. Will your employee be controlled on this fair in Germany? How he will be controlled, since everybody knows that they are just coming for one day? Well, in practice, there are no much controls, but if you want to be legal and perfectly compliant to the rules, even for a half-day posting, you are obliged to fill the A1. You are obliged to declare that somebody is going to perform its work outside of Belgium. That's the rule. Then there is a question of course, being or not being controlled, but the answer is, well, yes, every single time, as I mentioned, even for 3 hours, when you step abroad, you have to be declared. Just to end up with this question, with a true story, we participated once in a seminar in Lille in France, and there was quite a bit of management members from different Belgian companies. And those management members, they were from the companies that are active in the posting advisory, and the secondment advisory to other companies. And we were all laughing because most of them had to be declared via A1, and they are on top of that, they are specialists in the field of posting secondment. But to be honest, only few of them had this A1 for this symposium, this conference in France, because they said, okay, it's only half a day. We will not do all this paperwork for half a day. It's like that, you take a risk. And I think that since you are aware that the risk can be high, there is no need to take any risk.
Thank you. Now we will listen, to conclude this webinar, we'll listen to Vincent Detemmerman. So I invite him here. Hello, Vincent.
Hello, everybody. Happy to be with you today. Michal Drab really succeeded in explaining things in such a way that that complicated matter was pretty clear. My congratulations. It's not easy. Social security system is of course the basic aspect to take into account when you post a worker, and you gave us very good tips and advices. It's true that you have to inquire about the rules as soon as possible, take your information, prepare the various documents, and don't hesitate to ask confirmation to local authorities whenever there is a doubt, because, well, the risks are rather high. I would add that in my experience, I work in the construction sector, and in the construction sector, workers are posted on a regular basis, mostly for short term. For short term, because there are fiscal aspects which makes it not advisable to stay for more than 6 months in another European country. So generally, the posting is shorter than that. There are also other aspects in social security. Working conditions, you said it, have to be respected. Minimal wages, working time, health and security, which is something very important in the construction sector. Which means that there are many things and formalities, of course. You have not only to declare your posting in your home country, in Belgium, by applying for A1, but most of the time you will have to declare your posting in the country of work, which is the case in France, Germany, Luxembourg, Netherlands, and other European countries. I would advise to start early, because some formalities may take some time. Think about some professional qualifications document to be presented or to be acquired. Training, which is mandatory for some functions in the company. For instance, in the construction sector, you will generally be required to have some form of basic health and safety training to operate machines in the construction business. Those are things that can take time. So start early. Of course, the reason why you will have to be extra careful when you post workers is that labor costs can represent a large part of your price. In services sectors and in the construction sector, it will be about 50% of the cost of a project. Meaning that if you don't take into account correctly the minimal wages that have to be paid, working time, and so forth, you can miss the point with your price and end up making lesser profit that you had expected. You said it with regards to Belgium and the risk of requalification and taxes and social charges to be paid abroad. That's one part of the risk. The other part is the fines you are exposed to if you don't respect the working conditions abroad and the health and safety conditions. Those fines can be very heavy and may lead to not the expulsion of your workers, but to a stop to their activities, which is, from a commercial point of view, something which is not advisable, of course. And in a worst case scenario, UK, for instance, if you don't take all your precautions, you risk ending up not being able to post your workers at all, which of course is not easy to tackle. You would have to hire workers locally, which is not necessarily easy in a time where there are shortages throughout Europe and the world, actually, in some qualified professions. So all those advice were very good, Mr. Drab. That was really nice. I would like to add that I had the pleasure with Brussels to work at the development of very nice online guides of posting, which is very comprehensive. We touch upon professional qualifications, and in the construction sector, we have mostly regulated professions in many European countries, so that's important. Health and safety conditions, of course, social security, conditions for the stay, the housing of workers, information to be provided to the workers, and last but not least, the fiscal aspects. Thank you, Laurent. You are giving us a preview of the guide, which is to be found online in the two languages of Brussels. Well, not really two languages, there are many more languages than that, but the two official languages of Brussels, which are French and Dutch. But of course, everybody knows that Brussels is the most cosmopolitan, one of the most cosmopolitan cities in the world, just after Dubai. And I dare say that there may be more English-speaking or other languages locutors in Brussels than French and Dutch-speaking people sometimes.
Thank you, Vincent. With the presentation of Michal and with your guide, the guide that you made as a manager of the international business at the Confederation Construction, I think that the people have or audios, they have the reflex now when they should have the reflex now and the awareness to post people following the rules and avoiding the fine. What's very interesting in the guide that you've set up is also the synthese that you made in the form of tables on how to prepare and how to detach to post workers abroad, which was
we tried to translate the idea that Michal put forward to have a checklist for your posting operation that can serve as a basis for the preparation, which is well needed. I must say by experience that posting a worker abroad may seem a daunting task when you do it for the first time. It takes time. You have many formalities, things to think about. The nitty-gritty is not easy, but once you made it successfully, the next times are much easier actually to perform. And in most of the cases, you don't post workers in many European countries simultaneously, so you will gain experience and avoid the pitfalls that can be there. I must add, just again out of experience, beware of the fact that despite the European Union, the free movement of workers and the free provision of services, when workers are posted across the borders, the social and work inspectorates tend to have some kind of radar, and you will have a risk of being controlled, which is much higher if you are a foreign service provider than if you're a national service provider. So you can be almost sure that if you post 2 times, you will be checked at least once.
Okay, nice to know. Thank you, Vincent. Thank you.
Thank you, Vincent, and thank you, Michel. Thank you all for participating today. I remind you that next Thursday will take place the next export talk, and the subject will be establishment abroad. So don't hesitate to subscribe. And thank you, and see you next week.
Thank you.
Thank you all. Bye-bye.
Bye.
Bye.
Bye.